Things are getting really wild with Melania Trump right now. She's showing the same familiar side we've seen before, doing everything in her power to avoid being served legal papers. Honestly, it's like she's channeling a pro boxer, dodging, ducking, and weaving to make sure those documents never reach her hands. So why all this effort? It revolves around Michael Wolff, the journalist, and a brewing lawsuit in New York that she clearly wants to stop. She's filed a massive $1 billion defamation case against him, and she's now using this service issue as a way to slow down or even block his case from moving forward. Just in the past few hours, Melania has submitted a brand new filing in federal court in New York. This is fresh, not something from last week or last month. In her letter brief, she's raising a number of complaints, which we'll get into. But at the core, here's the argument she's really leaning on. Her main point, the one she keeps repeating, is simple. The doorman got served, but she didn't receive the papers personally. That's it. According to her, because the documents went to the doorman at Trump Tower instead of directly into her hands, the service wasn't valid. Here's where it gets intriguing. Maybe the reason she wasn't served personally is that she's been actively avoiding it. As mentioned, she's bobbing and weaving like a pro boxer. She's constantly on the move, bouncing between Mar-a-Lago in Florida, Trump Tower in New York, Bedminster in New Jersey, and sometimes even the White House. She's making it extremely difficult for anyone to catch her in one place. It's like watching some elaborate shell game, or like she's an MX missile on a mobile launcher, constantly on the move so nobody can pin down her location. Basically, it's a high-stakes game of catch me if you can. But here's the thing, Melania and her legal team either don't get, or maybe they do and are just hoping the judge doesn't notice. This strategy of constantly moving and avoiding service, it doesn't actually hold up in federal court. It's not a legitimate legal tactic. You can't just dodge process servers indefinitely and claim that because you successfully avoided them, the case can't move forward. That's a losing argument, and we'll break down exactly why in just a moment. Now, here's where it gets really interesting, the juicy part. What she's probably aiming for as a backup plan, if her main argument fails, is to get the case transferred. She wants it moved from New York down to the Southern District of Florida. Why Florida? Think about it. If the case ends up there, there's a real chance it could be assigned to Judge Eileen Cannon, the same judge who's been notably favorable to Donald Trump in the past, including in his classified documents case. So you have to wonder, is this whole elaborate dance about not being properly served really just a ruse? Could the ultimate goal be getting the case in front of Trump's favorite judge? That's exactly what we're digging into here. To give some context, here's how all this started. Michael Wolff is a journalist who's been doing his job, investigating and reporting on public figures. Back in October, he received a demand letter. And this wasn't just any letter. It came on official letterhead from Donald Trump's lawyer, who also represents Melania. His name is Alejandro Brito. In this letter, he demanded, and yes, you read that right, $1 billion from Michael Wolff. $1 billion. Let that sink in. Why such an astronomical sum? It stems from reports in the Daily Beast and other outlets. Wolff had been very public about his journalism, including repeating statements from a subject of his book, Jeffrey Epstein, regarding Melania. Then there were other details already part of the public record, things that were out there for anyone to see. Through his investigative reporting, Michael Wolff dug deep, connecting the dots between Epstein and Melania, Trump and Epstein, and even Melania and the modeling world. We're talking about models, parties, young women, and all the surrounding rumors. Wolff made comments about what allegedly happened on Epstein's private plane, the infamous Lolita Express, and he even speculated about where Donald Trump and Melania might have first had sex. All of this came directly from Wolff's work as a journalist, his reporting, his writing, his investigation. Then he receives this demand letter demanding $1 billion. And what's the catch? He has to retract his statements and apologize for what they called defamatory content. The letter listed a long series of specific statements from the Daily Beast and other sources that they wanted him to publicly take back and apologize for. But here's where Wolf played it smart. Instead of backing down, instead of letting this massive billion-dollar threat intimidate him, he turned the tables. He beat Melania to the punch. In October, Wolf took the next step and filed his own lawsuit, which landed in New York State Supreme Court, the trial-level court in New York, despite the confusing name. It was actually a smart move. Having practiced law in New York State Supreme Court, I can tell you that for a case like this, it can be a stronger position than going straight to federal court. So what did Wolf ask for in his lawsuit? He requested a formal declaration from the judge, essentially asking the court to officially state that every one of the statements Melania's team was complaining about is either true regarding Melania and Epstein, or alternatively, that those statements simply cannot be the basis for a defamation case in the first place. He also asked the court to declare that the billion-dollar threat against him is an unconstitutional attempt to chill his First Amendment rights, his fundamental right to free speech as a journalist. When you break it down like that, it's pretty straightforward. Unsurprisingly, Melania's legal team was not happy. They didn't like that Wolf had turned the tables and filed first. Here's an important point about how lawsuits actually work. To get a case properly started, you can't just file the papers with the court. You have to serve them on the other party. This is called service of process. There are also jurisdictional rules that matter, but the basic idea is simple. You have to make sure the defendant actually receives the legal documents. Generally speaking, unless a judge or statute allows what's called alternative or substitute service, you usually have to physically hand the documents to the person you're suing. This is done through a process server. Yes, just like in the old movies where someone walks up, hands you papers and says, "You've been served." The documents have to actually be delivered into the defendant's hands. Here's what's been happening. Melania has spent most of October, all of November, and straight through the holidays dodging service. This isn't speculation. It's what's happening on the ground. In fact, dodging service is the centerpiece of her new federal court filing. She's arguing there's no personal jurisdiction over her because she hasn't been personally served. Do you see the pattern? She's playing a high-stakes game of whack-a-mole with the process servers. They try one location, she's not there. They try another, she's already moved. It's a deliberate strategy of evasion, but here's why this doesn't usually work in federal court. First, there are legal ways to get around someone who's actively avoiding service. A judge can approve what's called alternative service. If a person is deliberately dodging service, papers can ultimately be served on the state's Secretary of State, or notice of the lawsuit can be published in a newspaper, and that can count as valid service. The judge has discretion. They can decide the papers should be delivered here or there, sent by email, or even approve other creative methods to ensure the defendant is properly notified. So what did Michael Wolff's team do in this situation? They handed the papers to a doorman at Trump Tower. Think about that for a second. Her name is literally on the building, and she lives there at least part of the time. Copies were also sent to her lawyer. Clearly, Melania and her legal team know about this lawsuit. They're filing papers, responding to it, and actively participating. If I were Wolff's lawyers, I'd argue waiver. Their actions show they've had notice of the lawsuit and are engaging with it, which undermines their argument about not being served. In federal court, you can't play games with service the way Melania is attempting. There are legal tools to shift the burden back to the person evading service. For example, Wolff's lawyers can notify Melania's team, "You have 60 days to accept service, and if you don't, you'll be responsible for all costs of us having to chase you down and serve you." Federal judges, even ones like Judge Viscosal, who was appointed by Donald Trump, don't look kindly on defendants dodging service. They see it as a manipulation of the court system. That's her first argument, but it gets more interesting. Her second claim is that New York courts don't have personal jurisdiction over her. Honestly, when I read this, I laughed because it's almost absurd. Anyone familiar with New York knows Melania is here all the time. We're talking about shopping on Fifth Avenue, Spa days at luxury establishments, ladies who lunch at fancy restaurants, charity events, and most importantly, overseeing her son, Barron, who goes to school here. She spends a lot of time in New York, so claiming the state lacks jurisdiction over her is quite a stretch. Here's a little legal teaching moment. Personal jurisdiction generally comes in two forms: general jurisdiction and specific jurisdiction. Understanding the difference is key to why her argument is so weak. General jurisdiction means you're so connected to a state, essentially living there, that the courts can sue you for anything, for any reason, anywhere within that state. That's general jurisdiction over you as a person. Specific jurisdiction is different. It applies if you don't live in the state full time, but you're there enough for the events forming the basis of the lawsuit, the cause of action, happened in that state. Now let's look at the facts. The demand letter from Alejandro Brito, the lawyer representing both Melania and Donald Trump, was physically mailed to Michael Wolff in New York. That's where the billion-dollar demand landed. The threatening letter was sent to New York. Wolff lives in New York, and much of his work happens there. Given these facts, Melania's team is in a tough spot on the jurisdiction argument. Convincing a judge that New York doesn't have jurisdiction is going to be difficult. Finally, at the very end of their filing, they argue that even if the judge keeps the case in New York, it should be transferred by federal court to another federal district, specifically the Southern District of Florida, where she supposedly resides near Palm Beach County. Now, here's where it gets really interesting from a strategic standpoint. There are only 3 judges who handle cases near where Melania lives in Palm Beach County. Judge Rosenberg in West Palm Beach, Judge Middlebrooks also in West Palm Beach, and Judge Cannon down in Fort Pierce, Florida. Judge Middlebrooks is now on senior status, which means he has a reduced caseload. Realistically, if this case gets transferred down there, it's roughly a 50-50 shot between Judge Rosenberg and Judge Cannon. And you can see exactly what they're aiming for. They want Judge Cannon. The pattern is transparent if you look closely. So just to recap, Michael Wolff's team wants to keep the case in New York State Court where it was filed. That's their preference. Melania's team wants to first move it to federal court and then get it dismissed, either because she hasn't been properly served or because New York supposedly lacks personal jurisdiction over her. And if those arguments fail, their fallback plan is to transfer the case from federal court in New York down to federal court in Florida. Do you see the multi-layered strategy here? Here's how federal practice in New York works, which is important to understand. You can't just file a motion whenever you want, like in state court. In federal court, you need to request permission before filing. Usually that starts with a conference call with the judge. I've participated in dozens of these, so I can tell you how it plays out. During this conference call, you're essentially arguing your motion before it's even officially filed. It's like a ghost motion. You haven't submitted the formal paperwork yet, but you're already presenting your arguments, and the other side is presenting theirs. The judge listens, and if they think your position has merit, they'll say, yeah, that sounds like it has some basis. Go ahead and file the formal motion. After that, the official filing happens, the briefing schedule is set, and sometimes, though not always, there's an oral argument. In federal court, a judge will often just decide the motion based on the written papers. From my experience, I've filed dozens of motions to dismiss in federal court, and I can count on one hand how many actually had oral argument. Now, here's what the letter says, and the opening line is notable. It begins, "We represent the First Lady of the United States." So who is this we? One is Alejandro Brito, but there's also a firm called D.A. Piper involved. And here's the interesting part. If you go back to 2020 and 2021, D.A. Piper publicly said Donald Trump was unfit for office. They were critical of him, but now in 2022 and currently, they represent Donald Trump and Truth Social on corporate matters. So the same firm that criticized him is now one of his main corporate law firms. That's quite a turnaround, isn't it? The letter continues. We anticipate filing a motion to dismiss for insufficient service of process. See, they lead with what they think is their strongest argument.